I'm Silvio Capellari from the Brussels office of Arnold and Porter, and next to me sits my colleague Axel Gutermuth. There have been really many interesting developments in German competition law in the second half of 2012, and we look forward to talking about those in the next hour. Just before we start, a few housekeeping matters. You should have two windows on your screen, one with the two of us and another one with our slide presentation. You can enlarge either of them as you see fit. Second, questions are of course more than welcome. We would ask you to type them up and we will try to address them at the end of the webinar. However, we really want to make an effort to keep it to an hour. So we may not be able to answer all questions or in fact any question. However, in this case, we promise that we will get back to you promptly by email. And of course, also please feel free to submit any additional queries you may have after the webinar. And finally, after the webinar, we will circulate an ebook to all of you with various materials, including the slide deck we are using today. With this, I hand over to Axel, who will kick off with an overview of recent policy developments.
Thank you, Silvio. We are all waiting for the final adoption of the 8th Amendment Bill to the German Competition Act, the 8. GWB-Novelle, but it has not happened yet. As all of you will know, the German government tabled a proposed amendment bill last year, and we have presented or discussed the main elements of that proposal at our last German competition law update webinar about 6 months ago. The first chamber of the German parliament, the Bundestag, then passed the amendment bill in October last year, but the second chamber of the parliament, the Bundesrat, raised objections. And in particular, the Bundesrat did not agree to extend the application of the competition law to the statutory health insurance funds in Germany, the gesetzliche Krankenversicherungen, which so far benefit from a partial exemption of the competition rules. And the Bundesrat also raised 3 other objections, which are mentioned here on the slide. When the 2 houses of parliament disagree in Germany, they convene a meeting of the Interchamber Conciliation Committee, the Vermittlungsausschuss, and that has met for the second time already now, just 2 days ago on the 29th of January. But with the result that the discussions about the 8th Amendment Bill were pushed back to the next meeting of the Conciliation Committee, which will take place on the 26th of February. So we are facing a parliamentary deadlock at the moment, and it is not clear when the bill will finally be adopted. A second interesting policy development concerns sector inquiries. Over the last 6 months, the Federal Cartel Office, the FCO, has published final reports with regard to 3 sector inquiries, which it has conducted over the last couple of years. And one of them I want to mention in particular, that is the report on the household waste recycling industry, the duale Systeme as it is called in Germany. This industry used to be characterized by a monopoly because effectively there was a network which was part of one operator really that ran the household waste recycling system in Germany. And about 8 years ago, this monopoly was broken up and competition was introduced by a combination of legislative action, but also enforcement action of the Federal Cartel Office under the competition rules. And what's interesting about this report about the sector inquiry is that for the first time ever really, the FCO has tried to make an impact assessment to determine what the net benefit to the society was of its enforcement activity in this particular industry. And the FCO found that while the industry was still ran as a monopoly, the total cost of this household waste recycling system amounted to 2 billion euros a year, whereas today, with a competitive market structure, the total cost is only $1 million. So a total cost reduction of about 1 billion euros. Interestingly, the FCO said in a press release that impact assessments of enforcement action has been identified also by OECD members as one of their policy priorities for the current years. And so it will be interesting to see if other competition authorities, or indeed the Federal Cartel Office for other industries, will embark on similar exercises in the near future. The other two sector inquiry reports concern the district heating industry and the rolled asphalt industry, and I will come back on the rolled asphalt report when I speak about joint ventures. Finally, the FCO has launched one new sector inquiry regarding refining and wholesale of oil and fuel products. Just to mention here also a third policy development, which is the creation of market transparency units, in German Markttransparenzstellen. They have been introduced by a bill of parliament which was passed in December last year, and which creates two market transparency units, one at the Federal Cartel Office, which deals with motor fuel retailing at gas stations, and another at the Federal Network Agency, the Bundesnetzagentur, and that market transparency unit deals with wholesale markets in electricity and gas. The main purpose of both units is to collect information from the industry participants on issues like price developments and other relevant competitive developments. But the market transparency unit for motor fuels even goes beyond that, because the goal is to create a database that will be accessible to the general public and which shows almost live the real-time prices for motor fuels at effectively all gas stations in Germany. So a major push towards creating market transparency for the benefit of consumers by the creation of this database.
Okay, the next chapter is cartel enforcement, and I want to start out with some statistics. We had this slide already in our last update seminar or webinar in July 2012. And now we could fortunately add the figures for the entire year 2012. This slide shows over the last 6 years the total fines imposed by the Federal Cartel Office for hardcore cartels, and also provides information on immunity and leniency applications received by the FCO. A few comments on the statistics for 2012. First, as you can see, the aggregate amount of fines was almost 250 million euros. That is higher than in 2011, but still lags somewhat behind the 4 preceding years. These almost 250 million euros were imposed in a total of 14 cases, and exactly half of these fines were accounted for by the train tracks cartel, where the FCO published its decision in July 2012. And as I will elaborate later on, the members of this cartel now also face a massive follow-on damage action by Deutsche Bahn. Furthermore, on the fines, the FCO set a record in terms of fines for individuals, as it fined no less than 31 sales representatives and management members in 2012. This is clearly a particularity under German law, and most people think that it really does have a deterrent effect. On the number of immunity and leniency applications, you can see that the number of 51 is the second highest ever. And 5 of those, that's also interesting, were from individuals. And finally, the yellow block shows 37 cases to which these various immunity and leniency applications referred. And that is also an all-time high for the FCO, which means that the 3 decision bodies working on cartel busting will have quite a full plate over the next month and years. The first case I want to talk about concerns information exchange. In this case, this case was triggered by an immunity application by the German subsidiary of Mars, and as it turned out, this subsidiary walked away without a fine. The case involved information exchange among 4 producers of confectionery goods, and these 4 companies exchanged information about their respective rebate discussions with retail chains. In August 2012, Haribo, one of the 4 members, decided to settle with the FCO and received a fine of 2.4 million euros. This is already the 5th case since 2008 in which the FCO imposed a fine for information exchange. Most of these cases concerned the area of fast-moving consumer goods, and 2 other cases, for instance, concerned drugstore products and luxury jewelry. Luxury goods, not really jewelry. And I think the Haribo case is noteworthy for 2 reasons. First, the press release contains a pretty strong language. I have reproduced it on this slide, and it seems pretty clear from that language and also from subsequent statements by the president of the FCO that the FCO sides with the European Commission insofar as it considers certain types of information exchanges as a standalone infringement. So information exchanges can be fined even if they are not linked to an agreement on, for instance, restriction on prices, custom allocation, or output restriction. And moreover, this case also seems to imply, it's less clear, but it seems to imply that the FCO also sides with the European Commission's approach in the horizontal guidelines that information exchange about prices, future price components, or other highly sensitive information concerning future behavior can constitute a restriction by object, meaning that the authority can impose a fine without proving any effect of the information exchange. The second reason why I think Haribo is worth mentioning concerns the product market definition. The FCO faced the problem that the participants in this information exchange did not compete with each other on a product-specific basis. However, the FCO had to come up with some kind of horizontal relationship, and in the end decided that the 4 companies were competing for shelf space, and that this was sufficient to create or to assume such an horizontal relationship. This approach is different from the FCO's case law in the merger field, and I'm curious to see whether one of the participants may appeal the decisions of the FCO on that ground. Haribo will not file such an appeal. They have already accepted the FCO's decision. By way of update, just today, the FCO published a press release according to which it has imposed fines of a total of 60 million euros on 11 producers of confectionery goods, among those Haribo. And in the press release, the FCO identified 3 different cartels which concerned price coordination and or information exchange including the Haribo case. So as it turns out, the Haribo settlement was only the tip of the iceberg, and of course we will report in more detail on this much larger than anticipated case in the future. The second case I will be shorter on. It concerns a cartel in the power transformers area. In this case, the FCO imposed a fine of 24 million euros on 4 manufacturers. The fines would have been much higher, but all 4 participants received a twofold discount for successful leniency applications and for their willingness to settle with the FCO. The interesting feature of this case is that prior to the FCO, and then also to some extent in parallel, the European Commission had carried out its own investigation in the area of power transformers, and this investigation had led to aggregate fines of 70 million euros in 2009. 2 of the companies involved in the FCO's investigation belonged to groups that were fined by the EC beforehand, and as was to be expected, they made arguments about double jeopardy or the ne bis in idem principle. However, this principle did not apply and the arguments were not successful because the 2 authorities had dealt with very different infringements. The FCO had focused on customer allocation in Germany through collusive tendering, whereas the EC case had concerned a much broader and also less detailed market sharing arrangement between European and Japanese producers. Last case I want to mention, and only briefly mention, is the RTL Pro7 Sat.1 case, which concerned a fine for illicit coordination between these 2 companies on the encryption of digital TV programs. I mentioned the case first because the sheer size of the aggregate fine is quite significant, and secondly, because the commitment, the 2 parties also had to give a commitment not to encode for at least 10 years, so to stop the infringement for at least 10 years, and the same kind of commitment was required a few months ago for the Liberty Global Kabel Baden-Württemberg deal in the merger field to be approved. And just as a side remark, RTL, Pro7 Sat.1 are having a pretty difficult time with the cartel authorities in Germany at this point. And just recently, for instance, the Court of Appeals in Düsseldorf upheld an FCO decision prohibiting plans of the 2 companies to start an online video platform. Now I want to turn to a procedural issue, and I think this is really a very interesting, almost intriguing case. It concerns a decision by the District Court Bonn regarding the scope of legal privilege in the context of internal audits. I tried to kind of summarize the facts in this timeline. The most relevant facts are as follows. At the end of July 2010, the European Commission conducted a dawn raid at the UK subsidiary of a multinational group of companies. 3 days later, the parent was shocked and decided to ask an external law firm to conduct a group-wide audit in order to identify any additional cartel risks. The lawyers of this law firm went out and spoke with many managers throughout the group, including some managers at a German subsidiary of that group. And in October 2010, finalized its notes on the interviews with these managers. Then nothing happened for a few months until in July 2011, now the FCO in Germany opened formal cartel proceedings against a cartel in which allegedly also this said German subsidiary was involved. And in early August 2011, the FCO down-rated the subsidiary and, as you may have expected, seized the interview notes prepared by external counsel, which were unfortunately left at the premises of this subsidiary. The parent company argued that this seizure was unlawful because the documents at issue were protected by legal privilege. However, the court disagreed and turned down the request. The decision is quite complex and long, and on this slide I tried to distill the four main reasons the court put forward. First, it said that the commission proceedings and the FCO proceedings concerned different legal entities, different markets, and also very different cartel infringements. Secondly, and I think that is perhaps the most important argument, or with most weight, the documents at issue, these interview notes, were created before the German subsidiary had been made subject to the formal investigation opened by the FCO. So in other words, before the German subsidiary could have been part of a proper defense relationship with this external law firm. Thirdly, a rather technical argument, the power of attorney given by the parent company mentioned only the parent company itself rather than the entire group of companies. It also did not list or even refer in any way to the many subsidiaries and affiliates of that parent company. And I think this argument is yet another expression of the particularity under the German cartel rules, which always focus on the specific legal entity involved rather than on the group as a whole. So there's a certain difference to the EC rules. In other areas, in particular when it comes to fines and parent liability or successor liability, this aspect has played against the FCO, but in this particular case, it certainly has helped the authority. And finally, the court put aside all arguments based on EU law, simply stating that in its recent ACTSO judgment, the European Court of Justice had clarified that the scope of legal privilege under EU law and national law may differ. I think there are three important takeaways for internal audits, which even merit to be stressed in a separate box. First, legal privilege in Germany, and that has become clear, covers only documents that were created after a formal investigation by a competition authority has been started against the very legal entity at issue. Second, the power of attorney with regard to internal audits should always cover the entire group of companies, best by really listing individually the various subsidiaries and affiliates. And third, and that I would hope was already clear to everybody beforehand, the audit documents should always be stored, if at all possible, only at the offices of the external advisor, and not even a copy should be kept at the companies or subsidiaries involved. With this, I turn over again to Axel on developments in the merger field.
Thank you. Yes, it's been a busy year for the FCO in the area of merger control. In 2012, it has received approximately 1,200 merger notifications in total. That is about 100 notifications a month on average. In the time period July to December 2012, which we are focusing on now, the FCO issued 2 prohibition decisions, and in addition there have been 3 cases where the parties have withdrawn their notification during the in-depth phase 2 review phase. But the FCO has also granted 4 clearance decisions after conducting an in-depth investigation, and all of these clearances were unconditional, so without any remedy commitments. And indeed, because all of the phase 1 clearances in Germany are also without commitments, by law, that means that we have not had any commitment decision in Germany in the last 6 months. The FCO also has 5 ongoing phase 2 merger cases, which are listed here on the slide, which means that when we reconvene again in about 6 months for our next German law update webinar, we are certain to have a good number of interesting cases to speak about. I want to mention a couple of interesting points from the decisions. The first prohibition decision concerned the attempted acquisition by Lenzing of its competitor Kelheim Hygiene Fibers. These 2 companies are the only producers worldwide of a specific type of viscose fiber that is used in the production of sanitary tampons. And so the FCO on substance had a relatively easy case to prohibit the transaction because it treated the transaction as a merger to monopoly. The combined market share of the parties was 100%, and also other aspects of the market suggested that the combined entity would have a dominant position, which is still the relevant substantive standard under the current German law. But the real issue in this case was whether the German merger control applied at all, because the parties tried to invoke the so-called de minimis market exemption. Under that exemption, German merger control does not apply if the case concerns a product market that in Germany has a total market size of not more than 15 million euros. And so the parties argued that in this case, indeed, the total German demand for these viscose fibers was below 15 million euros. And whether that was indeed true or not depended on how the demand of one single customer was treated. And that customer had a production site for sanitary tampons in Germany, but purchased the viscose fiber through a central purchasing unit that was located in Switzerland. And so the FCO said that the demand that came from this specific company is really German demand, so from the country where the production site is located, and not Swiss demand, so the country where the central purchasing unit for this company was located. And in reaching this conclusion, and thereby finding that the German merger rules applied, the FCO really followed what the Commission has explained in its consolidated jurisdictional notice, specifically for this type of situations where a multinational company has production sites in different member states where the products are actually delivered to, as was the case here, but places the purchase orders through a central purchasing unit that is located in only one member state. And again, the jurisdictional notice states that in these instances, the revenues should be allocated to the countries where the production sites are located. So the FCO followed that guidance. It also found here indications that indeed the competition for the demand of these customers were really more in Germany than they were in Switzerland. So that was an additional argument that the FCO invoked. So this is one of the very rare cases in Germany that really turns on the question of the geographic allocation of turnover. The second prohibition was concerned a merger of hospitals in the city of Worms in Germany. And this is not the first time that the FCO has blocked a merger of neighboring hospitals, and it will probably not be the last time. And there are no really groundbreaking findings in this decision, but there are 3 aspects which I think are worth mentioning here. The first is that the acquiring hospital in this case was owned by the city of Worms. And the filing thresholds were only met in this case because the FCO aggregated the revenues of all activities of the city of Worms without further trying to identify, as the Commission would do, whether these activities are subject to a single independent center of commercial decision making. And so this is yet another case that underlines how the German rules concerning the aggregation of revenues for state-owned undertakings differ from the EU rules on this matter. The second interesting point in this case concerns the geographic market definition, because many of these merger cases are ultimately decided by the question whether the geographic market is very narrow, in which case the market share of the merging hospitals is typically high, or whether the geographic market is broader and then other hospitals and then the market shares of the merging hospitals are lower. So we don't have time to get into more detail on this question, but whenever there is a case concerning geographic market definition, this is an interesting precedent to look at. And finally, the companies in this case attempted to invoke the failing firm defense, which is not often the case. The FCO went through the three criteria and found that none of them were met in this particular case, and therefore it prohibited the transaction. Turning to the phase 2 clearances, all of them concerned horizontal mergers between competitors, but the decisions have not yet been published, so all we know so far about them comes from the press releases or the case summaries that the FCO has put out. But I want to give you a flavor of the aspects that were discussed in these cases, so you can go back to the decisions when they come out. The first case concerned the acquisition by Becton Dickinson of the company Safety Syringes Inc. And there the parties had a high market share on the horizontal overlap market, but in that case the FCO agreed that the overlap market was indeed a de minimis market in Germany, which prevented the FCO from objecting against the transaction with regard to the horizontal effects of the merger. So it reviewed conglomerate effects, but found that they were unlikely to result. And so the case was cleared. The second clearance concerned the acquisition by a Swedish company, Ratos, of Pernod Ricard's Aquavit brands. Aquavit is a type of alcoholic spirit. So in that case, the FCO found that the parties had high combined market shares in the relevant product market, that the next largest competitor was significantly smaller, and also that customers showed a high level of brand loyalty. So not an easy starting point for the parties. But nevertheless, the FCO cleared the transaction because it found that there were significant competing regional brands, even though the market was national in scope, that there has been recent market entry, that there were private label brands which had a significant impact on the competition in the market, and that there was also competitive pressure from other alcoholic beverages. The third case was the acquisition of Fenwal by Fresenius Kabi, and some of my colleagues were closely involved in that case, where the parties had a relatively high combined market share in blood transfusion technology and also some related markets. But according to the press release of the FCO, there were strong customers that purchased these products through tenders. They normally had multiple sourcing policies. The customers were able to switch suppliers, and there was also evidence that price competition was very strong. And so again, the FCO was satisfied that this transaction would not lead to the creation of a dominant position. And then the last phase 2 clearance concerned the joint venture between General Motors and Peugeot, and I will get back to that when I speak about joint ventures. And then finally, I've listed on this slide the 3 cases that were withdrawn by the parties in phase 2. I will not mention any details, but I just wanted to not to let you go away thinking that the FCO is only looking at horizontal unilateral effects. To the contrary, other theories of harm are also alive and kicking at the FCO. So one of these cases concerned a collective dominance, as it is still called in Germany, so coordinated effects, and another concerned a vertical effects that the case resulted into. And with that, I turn again to Silvio for developments in abuse of dominance. Thanks.
Yes, in this exciting area, I want to highlight 2 cases. The first one concerns an FCO investigation against Lufthansa. This investigation was triggered by complaints of several corporate clients of Lufthansa. And these clients or customers complained about Lufthansa making the availability of discounts and retroactive refunds conditional upon the customers transferring to Lufthansa information about their bookings with other airlines, including detailed information about the rates they paid to these other airlines. The FCO carried out an investigation both under the ban on cartels and the abuse provisions, and came to the preliminary conclusion that Lufthansa had likely infringed competition law. And in order to avoid a potentially very significant fine, Lufthansa then agreed to settle and to commit to eliminate the problematic clause from its standard agreements. At recent conversations with some of our US colleagues, it became clear that they had a hard time understanding the FCO's rationale, because they said, and I think there is some merit to that, in principle, it's a good thing if a customer tells one of its suppliers about the terms and conditions of the other suppliers, because that obviously is an incentive for the recipient of the information to improve its own offerings. So that brings us to the question of the FCO's theory of harm. And fortunately, 2 days ago, the FCO published the non-confidential version of its decision in this case, which sheds at least some light on this issue. The decision quite often refers to the unilateral creation of artificial market transparency, and it becomes clear from the decision that the authority was concerned and took issue with the combination of Lufthansa putting pressure on its customers to provide them with certain information, and then also the type of data transferred, meaning in particular detailed information about rates. The decision is not entirely clear whether the FCO considers this combination, coercion plus type of data transferred, as a restriction by object. It says probably it is such a restriction by object, but it can be left open because in any event it is a restriction by effect. And on effect it said that the information obtained from the customers enabled Lufthansa to distort competition on specific routes on which it could react to the information it had received through, for instance, targeted rebates or other short-term measures, making Lufthansa's offer more attractive to the customers than that of other airlines. So the theory of harm is still not entirely clear, but what is clear, with this case, the FCO sends a strong warning to potentially dominant companies not to put pressure on their customers to provide the dominant company with highly sensitive information about the offerings of other suppliers. The second case I want to mention, and it's actually not really a case yet, this concerns an FCO investigation into the pricing policy of Deutsche Post. And this investigation was triggered by complaints of competitors, smaller competitors of Deutsche Post, because Deutsche Post allegedly has put in place abusive below-cost prices for mail services which it offers to large volume customers, such as telecom companies, banks, or health insurance funds. And the interesting part of this is, first, of course, the case received enormous publicity in Germany, because Deutsche Post, of course, is one of the top companies in Germany. However, also because this is the first investigation of the FCO since the Lufthansa Germania case in 2002, which focuses on classic predatory pricing allegations. After 2002, the FCO had confined its enforcement practice in that area to some cases under a specific provision that concerns below-cost prices by trading companies. However, the relevant legal standard for these cases is rather straightforward, because you have to compare the purchasing prices of the trading companies with their subsequent sales prices. By contrast, in the field of classic predatory pricing, the benchmark still is this ACTO decision of the European Court of Justice of 1992, which the court just recently in Danish Post confirmed to be still the relevant standard. And that standard consists of a two-prong test, a cost-based test. First, prices are illegal per se if they are below the dominant company's average variable costs. And second, they are also illegal if they are above the average variable costs but below the average total cost and form part of a plan to eliminate a competitor or to deter entry by new suppliers. The FCO has sympathized with these criteria, but has also acknowledged that, like the European Commission, by the way, has acknowledged that these criteria are very difficult to fill with life. Among the main challenges is the determination of the relevant cost categories and the allocation of costs to these categories. And also the assessment generally requires quite some data input from the allegedly dominant company on its cost structure and also on its price determination mechanisms. In the Deutsche Post case, there may be an additional complication by the fact that Deutsche Post may have engaged in a cross-subsidization between mail services in the so-called protected areas, where it still has a monopoly and therefore can charge supra-competitive prices, and then a transfer of these profits to areas like mail services for large volume customers, which are supposed to be open to competition. Again, this is all speculation. We are at very early stages in this case, and the FCO has not made a single statement about its investigation, but clearly it's a very hot topic, and we will follow the developments closely. One of these developments may be an amendment to the German Postal Act, according to which the Deutsche Post tariffs for all its customers may be made subject to pre-approval by the Federal Network Agency. At this point, such a pre-approval scheme applies only to Deutsche Post's prices that it charges to small customers and households. So, next on the agenda is the FCO's new interest in the scrutiny of potentially illegal joint ventures. That's again Axel.
Thank you. And indeed, this is an area where very important developments have taken place, which are of relevance not only with regard to the assessment of joint ventures in Germany, but certainly throughout Europe, because they concern Article 101 issues. And if I had a bell I could ring to make sure each and every one of our participants is listening carefully at this stage, I would certainly ring it now. Because, as I say, there have been important developments. So in November, the most important one is that in November last year, the FCO prohibited and dissolved under Article 101 of the Treaty of the Functioning of the European Union and paragraph 1 of the GWB, a joint venture that the FCO had cleared 16 years ago under the merger rules. That is the CVH Chemie Vertriebs joint venture, which is active in different chemical trading markets in Germany. And the situation here was that both of the parent entities also remained active on these markets. So the parent entities competed against each other and also with the joint venture. As I said, the FCO granted merger clearance when the joint venture was formed in 1996, but then started an investigation in 2008 under Article 101 and the German paragraph 1 GWB, because it thought that the joint venture would lead to a coordination of the competitive behavior of the joint venture parents and therefore to a restriction of competition. And indeed, in November last year, the FCO took a decision to that effect. So it found a restriction of competition, a violation of Article 101 and paragraph 1 GWB, excuse me, with a consequence that under the German law, the joint venture agreement is null and void, and that legally speaking, the joint venture does not exist. So massive consequences. It's not clear at all how this will play out under German civil law, to say that a joint venture that has been around for 16 years suddenly doesn't exist legally. In addition, however, the FCO ordered the dissolution of the joint venture. It did not impose fines, though. It will not surprise you to say that this decision has been appealed. Now, on substance, what was the FCO's reasoning here? The FCO said that, or found that the parents, as I said, are competitors and compete with the JV, and that the combined market share of the three was at least 30 to 40% on a broad market definition. Market shares were higher if markets were defined more narrowly. So the issue was whether the joint venture led to a coordination of the parents' competitive behavior and therefore to a restriction of competition. Those are the so-called coordination effects that can be caused by a joint venture. Now, interestingly, although this is the key question of the decision, it is dealt with on only 7 pages, leaving aside the market definition and market share calculation issues. And the FCO applied criteria that were established by the German Federal Supreme Court fairly recently. The Supreme Court said that there is a rebuttable presumption that a restriction of competition between parent entities of a joint venture occurs if the parents both are active on the markets of the joint venture, because under these circumstances, parent coordination is economically useful and commercially reasonable. In German, it is wirtschaftlich zweckmäßig und kaufmännisch vernünftig. And that is because economically, a joint venture parent will not have an incentive to compete aggressively against its own joint venture, because by doing so it will take away profits at the joint ventures, but ultimately that means its own profit will shrink. So the FCO in this case applied this assumption and said that there were no reasons that would rebut the presumption, and therefore we had a restriction of competition. The FCO very briefly also looked at potential exceptions or exemptions under Article 1013 and paragraph 2 of the GWB, but found that there were no grounds for an exemption. Now, some of you may ask how it can be procedurally that the FCO cleared the creation of the joint venture back in 1996 and now 16 years later turns around and says that the joint venture constitutes an illegal restriction of competition. And there one really has to distinguish the situation in Germany from the situation under the EU merger regulation. So if a joint venture is created and the EU merger regulation applies, then under Article 2.4 of the merger regulation, the Commission has to look at the coordination effects that result from the creation of the joint venture. Now, in parentheses, I would note that it's not entirely clear under the system of direct applicability of Article 1013 that it's impossible to challenge even such a joint venture later under Article 101, but let's leave this aside. At least it is sure that the Commission will look at the coordination effects within the context of the merger procedure. In contrast, or by contrast, in Germany, the FCO has discretion. It can review coordination effects within the merger procedure, but it can also decide to clear the joint venture under the merger rules and to reserve the issue of coordination effects for a subsequent review. And so in these instances, there is a significant degree of legal uncertainty for the companies because they do not know necessarily whether the FCO believes that there is a real issue under Article 101 or paragraph 1 and 2 GWB or not. So this happened in this case CVH Chemievertriebs GmbH, but it's not uncommon in German merger control, and I gave you another example on this slide. So that was the big case regarding treatment of joint ventures. Now, the sector inquiry report for the rolled asphalt industry also includes very significant descriptions and discussions about the assessment of joint ventures under competition law, in particular in situations where both parent entities compete against the joint venture. What's interesting in the report also is that it covers situation where the parent entities do not necessarily both have joint control of the joint venture, but where one may have a minority shareholding only. With regard to the rolled asphalt industry, this industry is characterized by a high number of joint ventures. The FCO reviewed at least 130 and found that at least 60% of those are very likely to violate the competition rules, so constitute an infringement of Article 101 and or paragraph 1 GWB. So the FCO has invited the industry to fix the problem, so to say. But the report really is interesting also because the discussion of the treatment of joint ventures under the competition rules has a much broader significance than just for the rolled asphalt industry. For example, it also includes a long chapter about the situation when, as I mentioned, one parent only owns a non-controlling minority shareholding in a joint venture, and then there's information that flows from the joint venture to that parent entity, and assuming here that the parent and the joint venture compete against each other. In essence, the FCO suggests to apply the statements that the Commission made on information exchange in its horizontal guidelines 2 years ago. So this is a highly relevant document from a general policy perspective, and everyone who deals with joint ventures, in particular joint ventures between competitors, should review this document. Finally, I just want to mention a joint venture case that concerned the creation of a purchasing joint venture between General Motors and Peugeot. The decision has not yet come out, so there's not yet a lot we can say, but I wanted to highlight it here because it's one of the rare phase 2 decisions in Germany that concerned a non-full function joint venture. There are not many decisions on that scenario, so when the decision comes out, it will be very interesting to read. So with that, I turn back to Silvio for the final developments.
Indeed. This is the last chapter, and I see we are almost on time, I guess, because I will speed up now. Sorry, I was too fast even. First, on other relevant developments, a quick look at vertical restraints. The FCO continues to be very active in terms of imposing fines on retail price maintenance schemes or measures with equivalent effect. The latest example is a fine of more than 8 million euros imposed on the tool manufacturer TTS. And that company had threatened its retailers to impose commercial disadvantages ranging from worse purchasing conditions to contract suspensions if the retailers did not go along with TTS target prices. More importantly, at a recent conference, the president of the FCO stressed that vertical restraints will be one of the FCO's main enforcement priorities in this year. And he referred to two ongoing FCO investigations, one regarding the food retail market that has been going on for quite some time now, and secondly, one regarding the sports equipment sector, more specifically potential refusals to deal with Amazon.com. We don't know much about this case, but clearly the FCO attaches quite some importance to it. He also referred to the ongoing sector inquiry into the purchasing power of the major food retail chains, and it is to be expected that the FCO's final report on this inquiry will come out in the course of 2013. As before, the particular emphasis will be on enforcement action against naked RPM schemes or measures with equivalent effect. Finally, the hot topic of private enforcement. Here we just want to highlight the massive damage claim that was brought by Deutsche Bahn against the members of the train tracks cartel. As mentioned earlier, the FCO in mid-2012 had imposed a fine of 124 million on the companies involved. But the damages Deutsche Bahn is going after now are much higher. The company has not explicitly quantified its damage claim. However, in its court filing, it had to mention the so-called amount in dispute, Streitwert in German, and it had put up the number of 750 million euros. This shows that the financial exposure of cartel participants to follow-on damage claims can be much bigger than to the administrative fines imposed by the competition authorities. And that also becomes clear if one looks at individual companies. I have picked ThyssenKrupp, the main culprit according to the FCO. They had received a massive fine of 103 million euros. However, if the damage claim by Deutsche Bahn is successful, and really goes up to 750 million euros, ThyssenKrupp could face an exposure of up to 400 million euros because the company supplied more than half of the cartel-infested products to Deutsche Bahn. Interesting is also the somewhat different role played by voestalpine. They were the key witness in the FCO proceedings and got away with a comparatively modest fine of 8.5 million euros. This company is not covered by the follow-up action of Deutsche Bahn. Instead, voestalpine is understood to be now in separate settlement negotiations with Deutsche Bahn. And this, I think, highlights pretty clearly that companies are well advised to think about a comprehensive defense strategy as early on as possible in cartel cases, which should cover not only the administrative proceedings, but also then potential follow-on action. And in this case, it seems that voestalpine just decided very early on to cooperate at all fronts, and the final damage, financial damage to the company may be quite limited as a result of this strategy. Last point on private enforcement, and in fact of this entire webinar, concerns procedure in private enforcement cases. And there I just want to mention that the Düsseldorf Court of Appeals recently issued a decision in which it extended the famous Pfleiderer ruling of the European Court of Justice only to the court files. This means that in the view of the Court of Appeals, immunity and leniency applications that were transferred from an authority in an appeal procedure to the court and also accompanying documents are shielded from access by a potential private damage claimants. And the court just essentially took over the reasoning that a lower court had already applied with regard to this kind of documents in the FCO's file by saying that the leniency applicants or immunity applicants trust in confidential treatment of its documents, and also the public interest in effective cartel enforcement should prevail in general over the information interest of the damage claimant. And this is true all the more as, in the court's view, this information interest can usually be satisfied with the non-confidential version of the FCO's decision. I have some doubt whether this is always true, in particular if one thinks of the many cases that end with settlements and where the damage claimants have only scarce access to really useful information for their cause. But that is a very deep discussion we cannot have at this point. Instead, the last word from us is on this slide, 2 words. Thank you very much for your interest. We hope you really found this webinar useful. We have overrun by 4 minutes, so as we kind of had expected, there won't be a Q&A session right now. But please feel free to send us any questions that you may have, and we will get back to you promptly. Also, as you have heard from us beforehand, this is part of a whole series. We periodically put out newsletters on developments in Germany, and every half year we have a webinar on that topic, and we really hope to have you again tune in for our next webinar. Thank you and bye-bye. Have a good day. 12. First, as you can see, the aggregate amount of fines was almost 250 million euros. That is higher than in 2011, but still lags somewhat behind the 4 preceding years. These almost 250 million euros were imposed in a total of 14 cases, and exactly half of these fines were accounted for by the train tracks cartel, where the FCO published its decision in July 2012. And as I will elaborate later on, the members of this cartel now also face a massive follow-on damage action by Deutsche Bahn. Furthermore, on the fines, the FCO set a record in terms of fines for individuals, as it fined no less than 31 sales representatives and management members in 2012. This is clearly a particularity under German law, and most people think that it really does have a deterrent effect. On the number of immunity and leniency applications, you can see that the number of 51 is the second highest ever, and 5 of those, that's also interesting, were from individuals. And finally, the yellow block shows 37 cases to which these various immunity and leniency applications referred, and that is also an all-time high for the FCO, which means that the 3 decision bodies working on cartel busting will have quite a full plate over the next month and years. The first case I want to talk about concerns information exchange. In this case, this case was triggered by an immunity application
of the Parliament, the Bundesrat, raised objections. And in particular, the Bundesrat did not agree to extend the application of the competition law to the statutory health insurance funds in Germany, the gesetzliche Krankenversicherungen, which so far benefit from a partial exemption of the competition rules. And the Bundesrat also raised 3 other objections, which are mentioned here on the slide. When the 2 houses of parliament disagree in Germany, they convene a meeting of the Interchamber Conciliation Committee, the Vermittlungsausschuss, and that has met for the second time already now, just 2 days ago on the 29th of January. But with the result that the discussions about the 8th Amendment Bill were pushed back to the next meeting of the Conciliation Committee, which will take place on the 26th of February. So we are facing a parliamentary deadlock at the moment, and it is not clear when the bill will finally be adopted. A second interesting policy development concerns sector inquiries. Over the last 6 months, the Federal Cartel Office, the FCO, has published final reports with regard to 3 sector inquiries, which it has conducted over the last couple of years. And one of them I want to mention in particular, that is the report on the household waste recycling industry, the duale Systeme as it is called in Germany. This industry used to be characterized by a monopoly because effectively there was a network which was part of one operator really that ran the household waste recycling system in Germany. And about 8 years ago, this monopoly was broken up and competition was introduced by a combination of legislative action, but also enforcement action of the Federal Cartel Office under the competition rules. And what's interesting about this report about the sector inquiry is that for the first time ever really, the FCO has tried to make an impact assessment to determine what the net benefit to the society was of its enforcement activity in this particular industry. And the FCO found that while the industry was still ran as a monopoly, the total cost of this household waste recycling system amounted to 2 billion euros a year, whereas today with the competitive market structure, the total cost is only $1 million, so a total cost reduction of about 1 billion euros. Interestingly, the FCO said in a press release that impact assessments of enforcement action has been identified also by OECD members as one of their policy priorities for the current years. And so it will be interesting to see if other competition authorities or indeed the Federal Cartel Office for other industries will embark on similar exercises in the near future. The other two sector inquiry reports concern the district heating industry and the rolled asphalt industry, and I will come back on the rolled asphalt report when I speak about joint ventures. Finally, the FCO has launched one new sector inquiry regarding refining and wholesale of oil and fuel products. Just to mention here also a third policy development, which is the creation of market transparency units, in German Markttransparenzstellen.
I'm Silvio Capellari from the Brussels office of Arnold and Porter, and next to me sits my colleague Axel Gutermuth. There have been really many interesting developments in German competition law in the second half of 2012, and we look forward to talking about those in the next hour. Just before we start, a few housekeeping matters. You should have two windows on your screen, one with the two of us and another one with our slide presentation. You can enlarge either of them as you see fit. Second, questions are of course more than welcome. We would ask you to type them up, and we will try to address them at the end of the webinar. However, we really want to make an effort to keep it to an hour, so we may not be able to answer all questions, or in fact any question. However, in this case, we promise that we will get back to you promptly by email. And of course, also please feel free to submit any additional queries you may have after the webinar. And finally, after the webinar, we will circulate an e-book to all of you with various materials, including the slide deck we are using today. With this, I hand over to Axel, who will kick off with an overview of recent policy developments.
Thank you, Silvio. We are all waiting for the final adoption of the 8th Amendment Bill to the German Competition Act, the 8. GWB-Novelle, but it has not happened yet. As all of you will know, the German government tabled a proposed amendment bill last year, and we have presented or discussed the main elements of that proposal at our last German competition law update webinar about 6 months ago. The first chamber of the German parliament, the Bundestag, then passed the amendment bill in October last year, but the second chamber, they have been introduced by a bill of parliament which was passed in December last year, and which creates two market transparency units, one at the Federal Cartel Office, which deals with motor fuel retailing at gas stations, and another at the Federal Network Agency, the Bundesnetzagentur, and that market transparency unit deals with wholesale markets in electricity and gas. The main purpose of both units is to collect information from the industry participants on issues like price developments and other relevant competitive developments. But the market transparency unit for motor fuels even goes beyond that, because the goal is to create a database that will be accessible to the general public and which shows almost live the real-time prices for motor fuels at effectively all gas stations in Germany. So a major push towards creating market transparency for the benefit of consumers by the creation of this database.
Okay, the next chapter is cartel enforcement, and I want to start out with some statistics. We had this slide already in our last update seminar or webinar in July 2012. And now we could fortunately add the figures for the entire year 2012. This slide shows over the last 6 years the total fines imposed by the Federal Cartel Office for hardcore cartels, and also provides information on immunity and leniency applications received by the FCO. A few comments on the statistics for 2020.